Okay, we're going to take a look at question 4 from July of 2015, straight community property essay. And let's go to the call of the question first, as we should always do. Number 1, what are Wendy's and Henry's respective rights? And you can always, my model answers don't abbreviate the names. You can abbreviate W, you can put W and H. Respective rights in, so number 1A, necklace. Okay, number 1B, car accident settlement proceeds. Settlement proceeds. And 1C, stock option profits. And number 2, should Henry be required to reimburse the community for his child support payments, and if so, what amount? So reimbursement for child support payments. I mean, they don't really hide the issues on any of these questions. So if you haven't read the fact pattern yet, pause this recording, read the fact pattern 2, 3, 4 times, just get really familiar with it so that when I go through it, it becomes very fluid and very easy for you to understand. Okay. It says answer according to California law. Now remember, there's only very few California specific subjects. Wills, community property, California evidence, California civil procedure, and professional responsibility, but that will say answer according to ABA and California authorities. So it's very limited, answer according to California law. You're pretty much looking at community property or wills. Not trust. Trust is not a California specific subject. So pay close attention to the details the examiners are giving you. Now another thing that's interesting with community property and wills essays and contracts is look at how they start. In 2008, second paragraph, 2010, 2011, 2012, 2013, 14, 15. The examiners go in chronological order. Now here you have to answer by the call of the question, but you're just going to take things in turn. It's real simple. It's a cinch by the inch. It's hard by the yard. You know, when you break this up, it becomes very easy. Don't try to swallow the whole thing. Let's just take a look at what happened in 2008. 2008, they married in California, so community property laws will apply. Neither had saved any money before marriage. Why are the examiners going out of their way to tell you that these jokers are broke? And the reason is because in order to get reimbursement for child support payment, one of the things that's required is if you use community property funds to pay off of prior child support payments, then the community is entitled to reimbursement up to the amount of separate property that was available. Up to the amount of separate property that was available at the time the payment was made. Well, think about this. And community property is pretty much a rule-based subject, where like subjects like torts and you're going to be using a lot of analysis, constitutional law, don't even get me started. But this is very rule-based, and it's very easy to apply once you know the rules. And I rarely say that, because a lot of essays do deal with analysis. Okay, so that's why they say neither had saved any money before marriage. And you have to put these things together. Of course, I'm going to help you, and the critical breakdown should do that as well. But realize when you slow down and you actually read carefully and you read the fact pattern several times, you're going to start picking up on these things. It's impossible to miss anything when you actually go, well, they're telling me that for a reason. There's got to be a reason there. At the time of the marriage, Wendy had a monthly child support obligation of $1,000, which was deducted from his salary, salary, community property, from a prior child relationship. So we know we're using community property funds because they said his salary. Now they're using community property funds to pay for a separate property debt that was incurred before the marriage, so the community is entitled to reimbursement up to the amount of separate property that was available at the time the payment was made. Well, in 2008, he hasn't got no money. But he does have a job. We do know he has a job because the money's getting deducted from his salary. Okay, in 2010, Wendy accepted a job at company. At that time, she was told if she performed well, she would receive stock options in the near future. Well, this goes here, and in 2010, she gets a job, which is nice because she didn't work for, looks like, the first 2 years. So this is some kind of employee benefit, employee compensation. And in order to determine anything that's earned during the marriage is community property. So it's earned during the marriage, it's community property. But sometimes you have to look at what the compensation is intended to replace. Is this intended to replace future earnings, or is it reward for past services? So we're going to have to break that down into past services or future earnings. Because what happens, if it's past services, and obviously the past services will be that the fact pattern will be when they get married, it's going to be community property. If it's future earnings for after they've been physically separated with no intent to resume, as we'll soon see, it's going to be separate property. Of course, anything that's earned during the marriage will be community property, and we're going to end up applying the time rule here. You know, that's the number of years they've been married divided by the number of years that the employment, the stocks were earned, or the pension, or the benefits, or whatever they were here, the stock options were earned during the marriage, would be community property. So you have to look at what it's replacing. If it's for past services, the community is going to have a much greater interest because labor during marriage is community property. Future earnings, after they've separated, not going to have that. So you have to look at the language. She was told that if she performed well, so she would receive them in the near future. So they haven't invested her, you know, there's no rights in at 2010. In fact, she doesn't even have, she just has a mere expectancy. She has nothing in 2010. But it says if she performed well, seems like they're going to be compensating for past services, which would give the community pretty good interest. 2011, Henry inherited $100,000. Inheritance, no matter when, regardless of when it was acquired, during the marriage, before the marriage, after the marriage, it's separate property. Inheritance is always separate property. So, and also, anything that derives from separate property remains separate property. If you make money off your separate property asset, it continues to be separate property. That's what the rents, incomes, issues, profits of a separate property asset will remain separate property. So here, he inherited $100,000. He used $25K to buy a necklace. That he gave to his wife as a holiday present. He used the remaining $75,000 to buy a municipal bond that paid him $300 per month. Well, it's interesting because remember, he's been making child support payments since 2008. He comes into this money at 2011. Now he's got all this separate property available. You can make an argument that because he put the money in a mutual bond, he didn't have, and this is what the sample answers in the State Bar was looking for. Sample answer said, well, the $75,000 technically is not available, but the $300 per month is available. So if he's using his salary to pay the $1,000 a month, it's going to be $300 per month from 2011 until the time they move out, which is 2 years later. So it's 24 months. I think it comes out to like $7,600. That's what the community is going to get reimbursed. Huh. That's what that sentence in there means. That's why they told you he was broke as a joke in 08, but then somehow his rich uncle died in 2011. Okay, so let's go back to the necklace. He used the $25,000 to buy a necklace that he gave Wendy as a holiday present. So, inheritance, he bought the necklace. It remains separate property because even though we transferred it from cash to, tangible asset, tangible property, it still remains separate property unless, of course, there was a transmutation, which means he gave it to her. And transmutation is an express declaration after 1985 that shows a change of ownership. And this is after 1985. Well, he didn't write down anything that said, like, I'm giving my wife this necklace, and I relinquish and give up all my rights in it, and I fully understand that I know that I'm making a change of ownership, that this is hers and it's no longer my separate property, and it's her separate property because I want to give it to her. He didn't write that. He didn't write that. So express declaration, change of ownership did not happen. So you don't have a signed writing for that. But you do not need a signed written agreement when you have a gift between spouses provided three things. Number one, it's of a personal nature, and it's a tangible article. And the personal nature, and the statute actually says, whether you wear it, jewelry, clothing, well, I think necklace hits the spot for jewelry. So got element number one, and all three things must be satisfied. Number two, primarily worn or used by the spouse who got the gift. And I have a feeling that unless, of course, Henry is a cross-dresser, the necklace is going to be used primarily by his wife. So we got element number two down. Element number three is where we make our money. And I'll tell you one thing, this is what the examiners are looking for. It has to be insignificant in value because it's gifts between spouse of insignificant value. It usually applies to, like, birthday presents, holiday presents, which is exactly what we have here. But you have to look at whether the value, is it insubstantial, or is it substantial, substantial in value, taking into consideration the circumstances of the marriage. I mean, how well are they doing? Well, let's take a look at something. In 2008, he bought her this in 2011. So this is the main thing. Is the necklace substantial in value? For a guy like Johnny Carson, it was a case with Johnny Carson I was just reading about this exact thing. We bought his wife a car. The issue was whether it was of a personal nature, because you can't wear it, it's not jewelry, it's not clothing. And it was physically, it was used by the spouse, it was actually pink. I think the car was like $50,000, $100,000, $200,000. But for a guy with $100 million, that ain't nothing. But here, it's $25,000. I mean, this guy didn't even have any money in 2008. We know he's got a job. We know she's got a job. But without more, I can't see how this is insignificant in value. So it's probably going to fail. And believe it or not, the necklace is going to be his separate property. As weird as that sounds, he gave his wife a gift, but because the gift was so expensive and there was no transmutation, then it remains his separate property. And that's what you have to do for the necklace in call to question number one. Okay, in 2012, Wendy was granted stock options by the company that would be exercisable in 2014. So here we go. We're going to do the time rule for this one. 2012, she has the right, earned during marriage. 2014, exercisable. So, as we'll find out in a minute, they actually end the economic marital community in 2013. End it, community. So, we'll get to the time rule there. Granted stock option would become exercisable in 2014, in part because she had been a very effective employee. So clearly this looks like it's past services, so the community has an interest in it. What is the community's interest? Well, if it was granted in 2012, and the economic marital community ended in 2013, which if you read the fact pattern a few times, you've probably already seen, but it's not exercisable until 2014. It takes 2 years to exercise them. She's been married 1 year. So the community interest in what she ends up cashing in to be $80,000 is the community has a 50% interest in it, because from 2012 to 2013, her labor, her skill, her effort is what contributed to her getting the exercisable options, and so it was only a 2-year option. So 1 year is community property, 1 year is separate property. So it ends up being 75% for the wife, 25% for the husband, because splitting up the community property 50-50 goes down to 25-25, and she already had 50% from her own separate property because the 2014 work. So that's how you get 75-25. Later in 2012, Wendy was injured in a car accident and made a claim against the person responsible. There we go. Settlement proceeds. So how settlement, now you look at not when it's settled, but when the cause of action occurred. When did the accident occur? 2012. And that's during marriage. So the settlement is community property. However, at divorce, the court is going to award the entire amount, the $30,000, entire award to the injured spouse. That's to her. And the reason, unless the interests of justice require otherwise, we don't have any facts to show that, and the reason is she's the one who has pain and suffering. She's the one who's going to be needing this money for future medical care, presumably. So the court's going to give her the $30,000. Of course, if community funds were used to pay for like some of the medical bills, then the community would be entitled to reimbursement. We don't have that on these facts. So odds are the entire settlement of $30,000 going to be going to Wendy because it's for her pain and suffering, her future medical expenses, and in part from what her injuries in the car accident. All right, 2013, Henry and Wendy permanently separated and Henry moved away. So that goes, you can actually put it either here in the beginning or you can put it here. I think it goes better here. So we have to talk about the end of the economic marital community. Economic community. And you have to have move out. That means permanently, physically separated, which of course it says he moved away. And the other one is no intent to resume. Those two elements must be proven. So number one, you must move out. One or two, no intent to resume. It doesn't look like in 2013, after Henry moved away, they had any contact. So you have to assume they have no intent to resume it. Even though it took her 2 years to file for dissolution, that's immaterial. The fact that they moved out and they never got back together, they didn't take any vacations, they didn't have any property together, they didn't have sex, they weren't holding themselves out in a married couple, they didn't go to marriage counseling. So no intent to resume. Clearly he moved out. So that's when the marital economic community ended in 2013. That's how we get the 50% interest in the stock options there. 2014, Wendy settled her accident claim for $30,000. Again, it occurred, the cause of action occurred during the marriage. It's immaterial that it was settled later. It goes by the time when the injury was inflicted, which is in 2012. And clearly in 2012, the party was still together. So again, like I said, this is community property, but at divorce, it'll be entirely awarded to Wendy because she was the injured spouse. Unless, of course, the interests of justice require otherwise, which is highly unlikely based on these facts. Later in 2014, Wendy exercised her option and earned a profit of $80,000. So the $80,000 is going to be split up 25% to him, 75% to her. And if I could do the math real quick, I think it's 60-20 if I'm not mistaken. 2015, Wendy filed for dissolution. Okay, what are their respective rights in the necklace? Again, the necklace was from money that was inherited. So the inheritance is separate property, remains separate property. There was no express declaration showing a change of ownership. There was no writing signed by the adversely affected spouse, which would be Henry. He did not say he was giving up his rights. So we don't have an express declaration. But we do have an interspousal gift of a personal nature. It was jewelry. It's primarily used by the wife. However, based on what we know, it was too expensive. And so it was not insignificant enough to just be a normal transfer without a writing. So it fails to be a gift, an interspousal gift of an insignificant value between spouses. Therefore, it remains Henry's separate property. Settlement proceeds. The cause of action occurred during marriage, which means it's community property. Again, at divorce, the court's going to award it to the injured spouse unless the interests of justice require otherwise. Stock options. To the point that they were earned during the marriage, it's community property. And it seems more likely than not, it's intended to replace past services because it says if she performed well, which she did in 2010 to 2012, and even up to 2014, they even said again in 2012, in part because she had been a very effective employee. That again goes to past services. It's not meant to replace future earnings. So they were granted in 2012, exercisable in 14, that's 2 years that the options will take to mature and to vest. Because she was married for one of those years, community gets a 1/2 interest in them, 50%. And because the other 50% separate property, when you divide the 50% community property, you get 75% for her, 25% for him. And finally, reimbursement for child support payments. When community funds are used, and he uses salary to pay for it, the community is entitled to reimbursement, but only up to the amount of separate property that was available at the time the payments were made. 2008, he didn't have any money. 2009 doesn't look like he had any money. 2010, it doesn't look like he had any money. But 2011, he comes rolling in it. He got the $100,000. He blew $25 on the necklace, and he put $75,000 in a municipal bond. Technically, you could say that money was available, and that he has to pay for all 1,000, or what the examiners were actually looking for, which I find a little confusing, was that because he was getting income and rent of profits of $300 a month, because any income derived from separate property is still separate property, so he has at least available $300 per month, and they ended it in 2013, so that's a total of 2 years or 24 months. $76,000 will reimbursed to the community, which means she'll get her half of what was that, $3,800 or something? So there you go. And you know what? That was, community property essays don't tend to be that difficult. So there you go. That's a wrap for July 2015 question 4, straight community property.